Question of proprietary rights in revenue courts, section 239. So section 239 is about the procedure when plea of proprietary right raised. It says that if any suit or proceeding in a revenue court is a question of proprietary right in respect of land forming the subject matter of such suit or proceeding is raised, such kind of question is raised in a suit or proceeding that is in a revenue court, and such question has not previously been determined by a civil court who has a competent jurisdiction, the revenue court shall frame an issue on question of proprietary right and submit the record to the competent civil court for the decision of the issue only. Explanation 1 states that a plea of proprietary right which is clearly untenable and intended solely to oust the jurisdiction of revenue court shall not be deemed to raise a question of proprietary right within the meaning of this section. Explanation 2 is about a question of proprietary right does not include the question whether such land is khudkasht. Subsection 2 is this, that the civil court, after reframing the issue, if necessary, shall decide such issue only and return the record together with its finding thereon to the revenue court which submitted it. Subsection 3 is that the revenue court shall then proceed to decide the suit accepting the finding of civil court on the issue referred to it. Subsection 4, an appeal from a decree of revenue court passed in a suit in which an issue involving a question of proprietary right has been decided by a civil court under subsection 2 shall lie to the court which, having regard to the valuation of the suit, has jurisdiction to hear appeals from the court to which the issue of proprietary right has been referred. Subsection 5, a second appeal from a decree or order passed by a civil court in appeal under subsection 4 shall lie to the High Court on any of the grounds that are mentioned in section 100 of the Code of Civil Procedure 1908. Is the question of tenancy right in civil court. It is mentioned in section 242. Procedure when plea of tenancy right raised in a civil court. So first subsection is this, that if any suit or relating to agricultural land that is instituted in a civil court, any question regarding tenancy rights arises and such question has not previously been determined by a revenue court of competent jurisdiction, then the civil court shall frame an issue on the plea of tenancy and record to the appropriate revenue court for the decision of that issue only. Explanation: a plea of tenancy which is clearly untenable and intended solely to post the jurisdiction of the court shall not be deemed to raise a plea of tenancy. Subsection 2. The revenue court, when the reframing of the issue is done, if necessary, it shall decide such kind of issue only and return the record together with whatever finding it has to the civil court which submitted it. Subsection 3 is this, that the civil court shall then proceed to decide the suit accepting the finding of revenue court on issue referred to it. Subsection 4, the finding of the revenue court on issue referred to it shall, for the purposes of appeal, be deemed to be part of the finding of a civil court. Now, conflict of jurisdiction is section 243. Section 243, power to refer question of jurisdiction to High Court, where either a civil or a revenue court is in doubt whether it is competent to entertain any suit, case, proceeding, application or appeal, or whether it should direct the plaintiff, the applicant or appellant to file the same in a court of the other description. The court may submit the record with a statement of the reasons for its doubts to the High Court. Subsection 2. Where any suit, case, proceeding, application or appeal having been rejected either by civil court or by a revenue court on the ground of want of jurisdiction is subsequently filed in a court of other description, the later court, if it disagrees with the finding of the former, shall submit the record with the statement of reasons for disagreement to High Court. Subsection 3, in cases that are falling under subsection 1, the court is a revenue court that is subordinate to the collector, and no reference shall be made under the foregoing provision of this section except with the previous sanction of the collector. Subsection 4, on any such reference being made, the High Court may order the court either to proceed with the case or to return the plain application or appeal for presentation to such other court as it may declare competent to try the same. Subsection 5, the order of the High Court shall be final and binding on all the courts that are subordinate to the board. That's all. Thank you.